Boom, right on 7 o'clock on the 2nd, I dare say. Good evening, everybody. Get your Fs out of the way now and let me know if the audio is good. What can you say about the state of the world? Other than try to laugh. Does everyone in the audience know how to identify when someone is fake laughing or forcing a laugh? It's a very, very interesting thing, which I will get to right after this. Love your parents, children, brothers, neighbors. I agree, point curation. Okay, who knows how you determine if someone is fake smiling? In my experience, the authentic smile goes upwards, and when someone is fake smiling, it's always pulled backwards. And I can detect it. I think 9 out of 10 times. I think I'm that astute when other people are faux smiling. But I keep saying you gotta smile, because if you don't smile, the alternative is crime. And an interesting thing also, when you catch it in a split second or when you catch a snapshot, sometimes it's virtually impossible to determine the difference between a smile and a cry on a still frame. So, fake laughing. I'm not. There's a science, by the way, that when you force yourself to smile and force yourself to laugh, it actually changes your chemistry. I don't know. I might be making that up. Audio is great. No Fs at all. Okay, excellent. I got my new mic for my camera. Some of you might have noticed it. I noticed a bit of distortion, but I might have not tinkered with the audio at all after shooting the video. But whatever. I got my new mic. Audio's better, so I don't have to rely on the other mic there. Whatever. The built-in native mic to the camera. Before we get to this, I heard Montreal rioted the other day. Were those hockey riots or maple syrup riots? Well, I didn't hear about the riots, but tonight there's a protest starting at Jean Mance Park, which is where I was earlier today, where I snapped. It's actually just kind of a beautiful picture. Totally, I put it on Twitter. I sent it in locals. I'm going to share it in the community on YouTube. But the Tam Tams, Parc Jean Mance, beautiful statue, people drumming, cops everywhere, and a shirtless guy wearing red shoes with the letters ACAB on his chest as he passes the police. So it was a juxtaposition of everything and just symbolic of the time. What was I going to say? So apparently there's going to be a protest starting at 8 o'clock there to protest the curfews. And here's an F for Ontario, because we've seen what happens when there is peaceful protest to excessive government measures. And let's get into this. This will be the intro rant while we wait for Robert and until I get into my standard disclaimers, which we'll get into afterwards. So for those of you who don't know, I put out a video last night, and it's the most absurd, random thing that I can put out a video breaking down the Google class action lawsuit. We're going to discuss it tonight. Take hours to research, read through the lawsuit, make the video, edit it, fun editing, etc., good audio, good lighting. Then I go do a Viva on the street where I'm walking down a dark country road only lit by periodic street lights. So half the video is my face totally in the dark silhouette, and then half of it is my face lit. 15 minutes of talking about the situation of the world. 70,000 views, and people are. I hope people are sharing it so people know what's going on and people can get an overall feeling of the situation. For those of you who don't know, Ontario is apparently having a third wave, and I say apparently they're having a third wave. Their numbers are what they are reporting on the government websites. 650 people in ICU. Last time I checked, it might be more now. 1,500 or might be more hospitalized. So they're having the numbers that they're having, and in order to deal with those numbers, they've gone into full. Well, what Doug Ford said was, stay at home. If you leave your home, you have to have a good excuse. Empowered the police to basically forget stop and frisk. This is stop and ask for your justification for being out of your house. They shut down outdoor recreational facilities, soccer fields, tennis courts, boat launches, playgrounds, and as though that's somehow going to resolve the situation or even help, as opposed to exacerbate. And so I have Yeah, 650. No, they have more. They have more than 650 ICU beds. They just have 650 in ICU, which warrants shutting down a province of 14.5 million people. So I'm having a discussion with a friend, and a good friend, on social media, where they posted a link to an interview with a doctor who's saying shelter in place is the only way we can deal with this. And then explains a problem which not only would not be resolved by a shelter in place, but would only be exacerbated by it, which, according to this doctor, the majority of the spread is coming from essential workers who are living in cramped family conditions for whatever the reasons. I think she was being politically correct by not explaining, by not delving into what she was explaining to be the problem. So the essential workers are out there working and go home to living with multi-generational families, where they then spread it to the family members. These essential workers are going to remain essential workers anyhow, and by forcing everyone to stay at home, it seems that you would only exacerbate the problem. So I explained my issues with this, that in the cure, the remedy cannot be worse than the disease, on the one hand. Second thing, there has to be some causal connection between the measures you're proposing, shutting down playgrounds and boat launches, and giving officers the authority to stop and frisk and make sure you have a good reason to be out of your house, is not going to do anything. All that it's going to do is vaporize whatever remaining civil rights you have and empower the government to say, we can lock you in your house. We can do unconstitutional things which have absolutely no scientific correlation to the objective sought, and just do it because you're virtuous for doing it and you're venomous for questioning it. And we have a back and forth. And then sure enough, 6 hours later, Doug Ford retracts the very measures he imposed the night before, partially because the police said, we're not going to do this. Now, some are saying good for the police for standing up. Others are saying it's a political move by the police because they don't like Doug Ford and they want to get him out of office. Doing the right thing for the wrong reasons, you can question motives all you want. Doing the right thing for the wrong reasons is still better than doing the wrong thing. So the police officer said, we're not doing this. And people were uproared, like, you're going to shut playgrounds down? You're going to shut swings down? And you think that's going to somehow resolve the lack of supplies and critical care availabilities? You got to have your head examined. And so he retracts them. And, and he retracts them and thinks now, like, he's going to get the brownie points for being reasonable. Look, I listened, I heard. And if you've heard Doug Ford talk, the way he talked when he implemented these measures, you would think he was talking to a third grader. So he retracts them, and now he's going to think that he somehow gets points for being reasonable. I said, the fact that he retracted these measures 24 hours after implementing them doesn't show that he's listening. It shows that he's not listening to begin with, and he doesn't know what he's doing, and it's just throwing darts at best and testing the limits at worst. So that's it. Let's see. We got, oh, hold on. Why can't I bring this chat up? Saw your vid last night. Compared your vids from last April and May. It makes sense why they, sorry. See, now the other thing, by the way, sometimes I bring up chats and I don't read them until they come up, and sometimes they're not always nice. I would ask everyone to, in as much as you respect me and my content, be respectful with the chats and the comments. Humor translates poorly online, and sometimes I'm sure people make things as jokes, which don't necessarily read as jokes. How do the most ridiculous people always get in power? Good question. Some people are willing to lock down a country, then be called a hypocrite. Well, or incompetent government, because I said these problems have been in the making for decades. Canadian doctors fleeing Canada to go to the US has been a problem for decades. The overwhelming of the hospitals during a bad flu season has been a problem for years. 2018, before the pandemic, they had to cancel elective surgeries in Ontario because the flu influx overwhelmed the hospitals. So this has been a problem for years. Now, someone says it's not a question of pointing fingers. We got to do what we got to do now. Yeah, do what you got to do to actually resolve the problem, not deflect the problem, not deflect the blame. I missed a big super chat. If the lockdowns work, why do they need to do them for the umpteenth time? Oh, yeah. Okay. Well, I'm going to just skip that one. And now I missed the super chat, which I can no longer get. Let me just see. It was from Gavin Cross. There was no comment, but Gavin Cross, thank you very much. Gavin is also a member. So that's where we are right now. And it's Quebec is still imposing the 8 p.m. curfew. The police are still implementing with great vigor The rules in this province, I went to the Tam Tams. It's called the Tam Tams. It's an outdoor park on Mount Royal, the most beautiful park on earth. People go there on Sundays to drum and do other things involving substances, which I do not do. That was not a judgmental judgment. I don't do it. But it was used. There used to be thousands of people there. I went there. I wouldn't say there were as many policemen as citizens. There were just an insane amount of police. And when crime is increasing, when specific types of crimes are increasing in Canada, in Quebec, and you are investing, wasting resources, the amount of police there was obscene to govern people socially distancing outdoors on a sunny Sunday afternoon when we have actual real problems in Quebec that are getting worse. But the government finds a way to slap down. I counted 20, at the very least 20 police officers surveying drummers and people dancing in a park on a Sunday. The American healthcare system is not solving the problem, and the U.S. system I think made COVID worse. Accountability, these people in government, if they breach rights, need to be imprisoned. Sovereign immunity. There will be lawsuits, and then another government in 10 years is going to apologize for the horrors of the government of the past. That's the way it works. You know, there is no accountability in government. It's only enterprise where incompetence actually results in the government giving themselves more powers. Look at the mess we made. We better give ourselves more powers to resolve it. Yuri Bezmans was right. He predicted all of this in the 70s and 80s. Well, I don't know who that is. People predict a lot of things, and then some of the things come true at some points in time, but predictions are only as relevant. Predictions coming true are only as relevant as the amount of predictions made, and you have to, be accurate and not predict a ton of stuff and then pinprick here. This one came true, therefore the prediction was accurate as a whole. Canadians need to read the StatCan report for the virus 2020 and the government's own reports on the website to get the info they aren't reporting. There is no question people should go check the stats for themselves and then come to the conclusions as to what the proper remedy is, because it's going to be a political solution. There will be elections, and I think there will be lawsuits in the long run, and I think the government will lose some of these lawsuits in the long run. Okay, we got Dave March says, I've met Ford. He is not bright. The stories I can tell you about the people running Ontario. There's also something to be said about who gets into politics, but that's a discussion for another day. Now, the collective outrage of the Ontarians worked, and the collective embarrassment on a global scale. Okay, that's it. Rant over. I see Robert is there, and he's looking dapper, and he's wearing something special tonight. Now, standard caveats. I may not get to all your super chats. Rephrase. I will not get to all your super chats. If you're going to be miffed if I do not get to your super chat, do not give it. I don't like people being miffed. If your super chat is abusive, I'm not going to read insults. And so if I can read them first, if I bring up comments, by the way, that I obviously did not mean to bring up, don't judge me. I do my best to read everything before I bring it up, but every now and again, the chat moves and I bring up a comment that I didn't want to bring up. What was I going to say? No legal advice. YouTube takes 30% of the super chats if that bothers anybody, and I understand it could. There are other places to support us. vivabarneslaw.locals.com. That's vivabarneslaw.locals.com. All right. With that said, we're going to bring in the master of the vivabarneslaw.locals.com plugs, Robert Barnes. Robert, how you doing?
Bien, bien. Is that the proper French?
Très bien, très bien. Formidable.
I still can't do that. I can't get close to the French. The language, it is something. Is it the nasal? Is it the?
It depends. So this is the distinction between Quebec French and France French. They say that Quebec French is more from the nose, and France French is more from the throat, from the guttural. But the language itself has rolling R's, and it's a language of beauty. It's also it's a very useful language. Robert, I think I forgot to say one thing. Oh, the menu of the evening. That's what I forgot to mention. On the menu, Chauvin update. Google class action, Project Veritas, Ahmaud Arbery updates, interesting discussion there. Ashley Babbitt and Dante Wright. We're going to be discussing this because I've got questions for Robert. I saw Robert's take on this, and I know I have questions. Rebel News suspended, and there's some other stuff. We'll get to it. But Robert, I just say first things first. Red bow tie. What is the occasion?
Oh, none. I just wanted to see. Someone sent it to me as a birthday gift. Plus, my brother sent these. I'm a big fan of The Thinker of Rodin. Love the museum in Paris, but wonderful, wonderful museum. It's one of my favorites. Carlos Museum in Mexico City. But So he sent me those, which are great books. And then my sisters were in Rhode Island, and they got me this book as a birthday gift. It's The Dorr Rebellion, which is has some ancestors that were stirring up some trouble back in the day. So so I feel like Hank Williams Jr., who has a great song called Family Tradition. And that's a reminder of the family tradition. My namesake was actually one of the 55 people that was killed in the Tower of London. And not everybody would take credit for that, but I'm happy to. So that's because he told the king that the king was bad, and the king decided to hang him. But, he got to live in history.
Yeah, these are the things when you go over history and you realize the roles that people played. But if you were to ask them, would you rather have lived as opposed to gone down as a remarkable moment in history? I suspect most of them would have said, I would have rather lived to 80 and, had a happy life. But alas, that's not in the cards for everybody. And speaking of which, going down in history, the Chauvin trial has been phenomenally interesting. Now, they're entering closing arguments starting tomorrow, correct?
That's correct. So the closing statements will be tomorrow. Closing arguments will be tomorrow. And the jury instructions will be tomorrow. Now, there might be or might need to be a motion for mistrial or at least to inquire into the jury whether or not they heard what happened over this weekend, including a member of Congress demanding that they convict. And if they don't, there need to be more people in the streets, more confrontation after a week in which, there was burning and looting and robbing and rioting. So what does more confrontation mean? But a member of Congress to go in and demand a jury give back a conviction on the top count, felony murder, or there's going to be riots. I don't know how the judge handles that, but he really needs to inquire into the jury about it.
Well, we're going to get there because it was even worse. She basically said he hasn't even been charged with what he should have been. So even if there's a conviction on the top charge, which was a lesser than what she thinks it should have been, that still won't be enough. But there might need to be a mistrial for another reason. You'll tell me if it's too late, if that ship has sailed. I guess. So the expert witnesses we've seen, it's sort of par for the course. Defense says one thing, prosecution says another. Three of their experts say one thing, and the actual individual who did the autopsy said another to some extent. But the big issue of the week was the defense expert testified or brought up an issue of potential carbon monoxide because of where George Floyd was positioned by the car, and brought that up as a hypothesis. I don't know how far they got into it. And so apparently the prosecution's experts were still watching the trial and contacted the prosecution attorneys and said, they've brought this issue up. Lo and behold, we ran a test on that to show that what they just brought up as a potential explanation couldn't be because the numbers wouldn't be where they needed to be. And the prosecution then comes in and says, we want to introduce this piece of evidence, which is only now being disclosed to the court and to the defense. And then the judge basically says, why wasn't this disclosed when you had your obligation of disclosure in the first place? And we're going to get to where it went, but the judge basically said no, and anybody refers to this, there's going to be a mistrial. I may have described that too summarily if anybody hadn't seen what happened, but first things first, explain to the world the obligations of disclosure in the context of a criminal prosecution, what that obligation is and how it plays out over time.
Sure. So this is constitutionally rooted. Now, you can have additional requirements under state law or under the professional ethical requirements of a prosecutor, but there's a certain minimum set of standards set by the United States Supreme Court, primarily in a case called Brady v. Giglio, but was also extended in multiple subsequent cases, made it clear it's applicable to both the federal government and to state prosecutors through the 14th Amendment requirement of due process and equal protection, which incorporates large parts of the remainder of the Bill of Rights. And so generally, if it's exculpatory information, they have to turn it over. And if it's information they plan to rely upon, it's information they have to turn it over. Generally speaking, almost anything related to the death, any test, medical examination, coroner examination, blood test, you name it, has to be turned over. And in this context, from a long time ago, they made clear the prosecutors cannot play the game of, well, we don't have it. This other agency over here has it. Supreme Court made clear, no, you can't do that. To turn it over, you're considered all part of the prosecution for these purposes. So they were supposed to turn over a bunch of information and documentation that they have waited throughout trial to do. On average, 500 pages a day, apparently, on average, of new discovery has been turned over each day during the trial. And it turns out they were sitting on their carbon monoxide testing. And maybe they hoped the defense would explore the possibility that carbon monoxide may have been a factor in Floyd's death, and then wanted to say, see, this was all nonsense, by hiding the test results from their experts and from the defense. And that's why the judge was very agitated about it. Now, to this judge's credit, there's a lot of judges that don't care that they had covered. The reason why prosecutors do this is they get away with it all the time. But it's why they risked it doing so here. So why, I mean, they had been doing it, ambushing the defense on a daily basis with new evidence and new information. I mean, 500 exhibits worth. That's insane. Now, I've been through that Snipes case. I didn't get almost any of the discovery until the night before the witness testified. So they were trying to drive me nuts with lack of sleep, but I don't sleep anyway, so it didn't matter.
One of the AMA questions for you, Robert, is how much do you sleep at night?
Yes, indeed. I got a fun meme on our board. VivaBarnesLaw.locals.com. If you're not there, you're not treating yourself. You shouldn't punish yourself by not being at VivaBarnesLaw.locals.com. You should treat yourself by being there. Enjoy a wonderful community of meme makers and commenters and posters, as well as enjoy exclusive video content and other content from Viva and I. But the one fascinating thing about this, would sort of a good bridge into, before the trial, I tested what our board members thought about the case. Did they think he was guilty of all charges, guilty of some charges, or simply not guilty, period? About 70% or so thought he was guilty of at least something, though most of them settled on something rather than everything. Now, same poll, same board, 70 to 75% so far think he is not guilty of any charges and all charges. And I think that reflects, in general, you have three categories of jurors, in my view. Jurors who came in saying he's guilty. That juror group, if you follow them on social media or other commentary sites, they haven't changed their mind at all. Second group, jurors who came in saying not guilty, definitely. They, too, haven't changed their mind at all, and they have more ammunition for their side of the aisle. Now, the group that came in saying maybe guilty, maybe not guilty, not sure, undecided, that group has overwhelmingly, the ones that I've been able to track, not only on our board, but in other places, overwhelmingly have shifted to a not guilty position. And that's because of what's happened at the evidence. And it's probably why Mad Max was going up there saying, you better vote guilty or we're going to burn your city down, basically, to paraphrase Mad Max.
Oh, no. So, well, before we get too far off, by the way, everyone knows what I thought from the beginning. And it's not, I may not have changed my mind because I'm stubborn, but I can definitely see how people could change their mind with this, or at the very least, people could have a reasonable doubt in a non-extravagant, non-hypothetical, non-stretch of a way. But what even more interesting is apparently when you shared that poll, or when you ran that poll on Twitter, Twitter was censoring the results in that it was only showing for
like 12 hours. 12 hours, it wouldn't show me the results. I think it was over 20,000 people that had voted in the poll. In the first 10,000, I couldn't see their results. Twitter, because obviously Twitter didn't like it. And I guess enough people complained, so Twitter backed off and let it be shown. And what it showed was similar to what we got on our locals board, which is that those people who are following the trial in detail, and what's notable here is it'd be one thing if these were all not guilty people beforehand. Instead, this is people shifting opinions. These are people who came in, large numbers of them came in leaning guilty. They weren't definite guilty, but leaning guilty. I mean, heck, when I first saw the video, I thought Chauvin was guilty. But that was before the police evidence. That was before the body cameras. That was before the toxicology report. That was before what I witnessed at trial. That was before I found out that body position, studies in Canada, studies in the United States, 3 different studies now have been introduced into evidence, at least indirectly through expert testimony. When they looked at this, the prone position, no matter the amount of weight, simply almost never caused death and almost never caused serious bodily harm, as contrasted to tasers, guns, batons, physical, other forms of force that could be utilized. That it turns out the prone position, at least from the available data, no risk that anybody can, or minuscule risk, like 0.2% risk. So given that, that's what changed my mind, was the evidence that was presented. But I think in terms of, here's the 3 questions that the jury has to answer. Do they believe beyond a reasonable doubt that Chauvin exercised unreasonable, unjustifiable force? Secondly, if they say yes to that, then they move to the second question effectively. And sometimes you have special verdicts. I don't think this will be a special verdict form, but they may go that route. But if it was a special verdict form, that would be the tree of decisions that they would have, the decision tree to go through. And if they say no, if they say this was reasonable force or wasn't unjustifiable force, that's it. He's not guilty across the board, all charges. The second.
Oh, sorry. Go ahead.
Oh, the second question is, if they answer yes, then did his excessive force, that excessive force they identified in question 1, did that excessive force proximately cause, or in this case, be a substantial factor in the death of George Floyd? And for that, it's important that people understand the interrelatedness between the two. So in other words, if they say, yeah, he used excessive force, but it was only the last 3 or 4 minutes, that his excessive force was once he had quit resisting or showing signs of physical resistance, he had an obligation to flip him up or at least turn him up so that he would be in a semi-recovery position and not at risk during that time period. But the question is, did that failure was a substantial factor in his death? And the reason why it's consequential is because the government's main medical expert said it wasn't. He said he was, and that's why the government had to come in this week and come in with a new use of force expert to say the entire prone position is unreasonable force. Now, this expert, by the way, makes law professors look bad. Basically, his expertise was if an arrestee complains, you should handicap him and you should unhandcuff him and call him an Uber. That was basically what that guy testified to. I knew that they had to go to this position because of their medical expert testimony, but I didn't find that particularly credible. But putting that aside, that's the second question. Was the period of the manner of excessive force what caused a substantial factor in the death? And then third, even if you agree to 1 and 2, there's different layers of intent for each of the 3 charges. For felony murder, they need to show that Chauvin intended to cause severe, serious bodily harm. And in Minnesota, you look at how they define that by analogy, it's disfigurement, disability, or death. It's not just pain. It's not you broke his arm. It's you're making him unable to see, unable to hear. It's almost the equivalent of death. That they just have covered situations where it isn't death, but you wanted to take his arm off or his leg off or make him blind, etc. That's felony murder. For the next count of third-degree reckless murder, they have to show he acted with a devious mind, which means that he had he knew that that what he was doing was creating a substantial and unjustifiable. This is where his subjective mindset about reasonable force comes into play, because reasonable force is just an objective test. Is a substantial and unjustifiable risk of death. And then second-degree manslaughter, the requisite level of intent, is a substantial and unjustifiable risk of serious bodily harm. Now, my view, as I've said before, is that some of these elements are so close that they're running into statutory and constitutional problems in Minnesota.
But they haven't raised any constitutional questions as to we've been going over it. Nate's been pretty vocal about it. Nate, the lawyer, that, in order to succeed on a felony murder case, a felony murder conviction, all you have to do is prove the underlying assault, that it substantially contributed to the death, and there you have felony murder. So you don't even need to prove the intent. It's strict liability. Is anybody arguing constitutional?
Only kind of. In other words, the way they solve the intent problem is the nature of the underlying felony that can count. And in Minnesota, there's 2 components of this. One is not any felony can count as felony murder. The judge is supposed to do a 2-fold analysis. And they did raise this issue statutorily and constitutionally before trial. So it's preserved for appeal. Is that for felony murder, they're supposed to say that statute inherently creates a serious risk of death. And secondly, that in the facts of the particular case create a serious risk of death before they can allow that felony to be a felony murder charge. The other way they preserve against the problem of basically any murder being a felony murder is they say that if the elements are the same between 2 criminal statutes in a particular case, then the person can only be sentenced to the lesser offense in Minnesota. the full scale of how this applies, like the way most courts have come to terms with this is they've adopted the merger rule. And the merger rule says if it's the same, if it's one act that's the same act, that's the murder and the felony, then you can't charge felony murder. Minnesota hasn't adopted that merger rule because in part it has these two other protections against it. But they have not addressed my question, which is what happens when those other checks on the process don't work and you effectively have the problem that the merger rule was meant to solve. The reason why most courts ultimately adopted the merger rule, the reason why Dershowitz thinks the Minnesota high courts will ultimately adopt it in this case is because of problems like this case, where if every murder can be a felony murder, and it's hard to see committing murder without also committing aggravated assault, then why have any additional levels of culpability for murder statutes? And that's what creates the problem. And ultimately, they have never addressed that. They've addressed the merger rule, but they haven't addressed my question. And so Nate cited 3 cases, but those 3 cases actually don't even reference the merger rule. Be careful before you cite those legal thesauruses, everybody. Now, Minnesota has refused the merger rule along the lines Nate said. But it's just a little tidbit. People make that mistake all the time, by the way. You have those little legal thesauruses, and you go there and you find the big quote. Some of my beloved tax protester clients, unfortunately, do this all the time. Like, oh, I got this quote. I'm like, that doesn't come from that case, actually. But the core issue, I think Dershowitz is right, that you look at the broad history, the felony murder rule is borrowed from common law in Minnesota. They've tried to solve this problem in other ways. This case exposes the risk of it because you start looking at the different levels of intent, and it seems off. I mean, Nate concludes that they're almost identical. So that's a problem.
It's a pure logical issue, is that if assault or what would otherwise be manslaughter leads to death, it will always be felony murder. Then there's no point in having manslaughter anymore. It's basic logic. So, but now basic logic, the law is not always logical, but whatever. So they've raised that objection. It'll be preserved on appeal if and when. But so actually, but the
intent is important. Like, there's a lot of people that are skipping over it. I mean, what evidence has been introduced that Chauvin intended to basically kill him, or in the case of felony murder, the equivalent of disability or disfigurement is how they basically analogize serious bodily harm. The same with the reckless murder. Did he know at the time he was doing the restraint, there was a substantial and unjustifiable risk of either death or serious bodily harm? I just, the only evidence for that, I thought they were going to have much better evidence. They could have presented such a clean case. They could have come in and said, the last 3 minutes is what killed him. The last 3 minutes is what was excessive force. These were all the people, including fellow officers, who warned him about this. And there's very little use of force evidence that supports the last 3 minutes because it was post-resistance. But they chose not to do that. They chose to put the media narrative on trial, to push and propagate the media narrative. You know, their own witnesses contradicted. I was talking with Robert Gruler about this, watching the watcher.locals.com. And I was asking him, like, have you ever seen a case where the government's own experts contradict each other as much as they have in this case?
Some people are going to say they didn't contradict each other because 3 of them were going with one cause of death. The other one was saying, I didn't see any positional asphyxia in the cause of death. But so they're going to say they're complementing each other but not contradicting each other. The 3 versus the 1 were not mutually incompatible, but definitely brought into question their respective conclusions.
Correct. And their use of force experts disagreed with one another. And not only that, their theories of the case, because putting aside the experts, they had the MMA guy accuse him of doing a blood choke. Then another person accused him of doing a respiratory choke. Completely false. Completely false.
I think the MMA guy got properly lambasted for his expertise. That's a silly. It was a bizarre decision.
If you're the prosecutor, why put that guy up? All you're doing is putting up a look at this live witness who was warning Chauvin of how dangerous this was because this was a blood choke. Oh, it turns out it wasn't a blood choke at all. Well, why have him testify? How does he help you? All he does is distract the jury.
Yeah, well, no, I think in general, the idea of an MMA fighter testifying as an expert in any case in which the MMA fighter is not a witness or a party, I don't see it going anywhere useful ever. But so now, and also just to close off on the expert issue, because so the prosecution, they run these tests, they disclose that which they're going to rely on as evidence, and they have to disclose that which is exculpatory. This idea here is we ran the tests, didn't find any carbon monoxide issues, therefore it was neither incriminating, therefore it was neither exculpatory, nor were we going to rely on it, didn't disclose it. Until the defense raises it, then they say, oh no, we have this, and now we want to use it to undermine one of the theories of the defense, and the judge says, when did you find this out? Why didn't you get this earlier? I saw Blackwell's explanation. He was skating as much as anybody could skate. Oh, they conducted it the night of. We only got it yesterday because the expert was still watching the trial and said, hey, we can respond to this point. First of all, my question is it normal for a prosecution's expert to continue watching after they've testified and act in unison with the prosecuting attorneys?
Extremely unusual. This is the guy who's one of the several witnesses who volunteered, which is also extremely rare. Agreed to work for free, also extremely rare. So and in my view, all it did is, it's what we predicted, that there were going to be a lot of experts on the prosecution side eager to be part of convicting Derek Chauvin. And that's a problematic aspect of the case. It's not uncommon for government witnesses that work for the government to follow the case, like a coroner, a medical examiner, et cetera. But very unusual to have a professional outside expert following the case. And for one reason, you just don't have them do so because it costs too much to do so. But when they're working for free, well, why not?
Well,
and the state has endless coffers.
Working for free, which typically indicates working for an interest other than financial. Some will say benevolence, others are going to say political interest. But now,
I have less confidence in people that volunteer to work for free in a case in general than someone who's paid, because that means they had an opinion beforehand, in my view. So my problem with a lot of the medical expert testimony was they again, because they were pursuing, they could have just stuck with the state medical examiner, said it was stress, the stress of the body prone position is what was a substantial factor in his death, but the heart disease mattered, the drug addiction mattered, the other issues mattered. That was a reasonable position to hold. That was the smart position to hold. Why prove something you don't have to prove? But because they want to prove the media narrative. This whole thing is a Soviet-style show trial. This is a guy who was willing to plead to third-degree murder before the case started and served 10 years in prison.
That's what people don't necessarily fully appreciate, but that wouldn't have been enough. I wouldn't go so far as to call it a Soviet era trial. There's definite political interest in this. This has definitely become not a litmus test per se, but rather the trial of the era that a lot of things are going to depend on, or might set the way going forward. But yeah,
to give example, some of the nutty things they had these experts say. They had one expert, their lead expert said that, 90% of the time smoking doesn't damage your lungs. And I was like, what? I was like, even if that's true, I wouldn't let my expert say it because it's going to make you sound like an idiot to the jury. Then they had another heart expert, say that having an enlarged heart with 90% occlusion in different arteries can be better for you than a normal heart. And then they had their drug toxicology expert get up and say, this level of fentanyl is such a no problem. You can just go out and drive comfortably with it. Why adopt ludicrous propositions like this? It was not necessary to their case, but I think it damaged their case with independent jurors. Whether they have that jury is another question. But I think they tried to prove the media's narrative, and the media's narrative was always a big, fat lie.
Okay, now, the judge says, though, he says, after all of this, no, we're not going back. You're not ambushing them right now with all of this new information, after you've closed your prosecution, when they're experts on a plane. And he says, if you mention it, there's going to be a mistrial. Now, a lot of people were dumping on the judge because apparently they mentioned it, or close to mentioned it, twice, where the judge had to step in, which he should have followed through on his word and declared a mistrial. What's your feeling on the judge not following through on his threat to declare a mistrial if they refer to that report?
I think Robert Gruler's analysis is correct, that they were referencing a different report, and that the judge and the defense lawyer were worried that they were referencing the impermissible report, but it looks like they were not going down that path. And so that's why I don't think that was a grounds for a mistrial by itself. Now, there's a whole bunch. The bigger issue to me won't be those evidentiary issues. it will be his decision to not sequester them even after the riots started again. I guarantee you this judge is not happy that what Congresswoman Maxine Waters did.
Okay, before we get there, because that's going to be the big one. Cleopatra says, I did not get to see the trial in its entirety. Did anyone bring up the very high chance of dying from fentanyl? I saw the part where the witness told how much fentanyl was in those pills in the car. Well, so Cleopatra, the evidence that the prosecution's experts raised, they brought in a graph and showed how people had been totally functional on higher levels of fentanyl, driving cars, et cetera, to show that, you know, what I guess there's always risk to any level of fentanyl, especially elevated levels. But their argument was that other people have done much better on much higher levels of fentanyl, so that couldn't have been the effective or substantial cause of death.
That was their. I mean, they basically had showed that 600 people had been arrested with a higher level of fentanyl. They also showed that more than 10,000 people had died with a lower level of fentanyl from fentanyl. So, and their own experts agreed that if they just looked at the body, they didn't look at the videotape and the news stories and the rest. If they just looked at the body and the autopsy report and the toxicology report, that they would not have concluded use of force caused the death. They would have concluded either a fentanyl overdose or heart disease or combination of the two caused the death, which was the defense's own expert.
It was a very interesting admission that, you know, I would have come to a conclusion based on the actual only analysis, not having seen the video. Now that I've seen the video, I got to retool my analysis. What would have otherwise been my objective, purely scientific analysis.
Which is unusual, as a lot of people on our board, vivabarneslaw.locals.com, a lot of them have medical background, and they pointed out and some forensic background of how rare this theory of, like, a lot of people are like, hold on a second, doctors are looking at videotapes and now determining cause of death. So I think there's the reason why Maxine Waters is up and about doing what she's doing is because there's serious fear of an acquittal, because those who've actually followed the trial in detail saw a very different story than the one the media has been spinning, as Jonathan Turley also pointed out.
Yeah, no, Turley's been pretty vocal about this. Now let's get into the Maxine Waters, because this is the next level obscenity. Maxine Waters gave an interview where you want to talk about Trump having delivered an insurrection-inspiring speech. Maxine Waters literally said, we've got to get more, what was the word she used, Robert? More
confrontational. If there's a not guilty verdict.
If there's a not, I think it was ambiguous as to even if there was a guilty verdict, but I think even if there's a not guilty verdict, we have to get more confrontational. The jury is not sequestered, meaning
they likely saw it.
Well, sequestered means what versus they're not supposed to be checking social media. If they're sequestered, it means
you're stuck in a hotel, usually without access to social media and definitely TV and newspapers. So that's what sequestered often means. Now, sometimes they let you keep your phone and allow certain social media access, which would be a problem. Now, he also turned down the request from the defense before trial to order them to not look at their social media at all. So that's why he's taking a huge gamble. I understand why he did it. He wanted people to have confidence in the jury trial outcome because it's a Minneapolis jury, racially diverse Minneapolis jury, that made an outcome that he thought that people would get confidence in if it was done that way, without sequestering people, without isolating people. But that backfired because it was all risky to begin with. Then they had the $27 million settlement get publicized. And this is how we know the jurors likely saw Maxine Waters, because they'd already been ordered not to look at anything for Floyd, and a bunch of them saw the $27 million settlement because you just can't avoid it.
That's what I was going to say. This is, I haven't been following. I did not see Maxine Waters' statements because I was looking for them. I in fact, it's been the weekend. I didn't even go out of my way to follow the news. I saw them because you can't avoid it anywhere. And so she comes out and she says this now, basically, effectively saying to the jury, if you acquit, there will be riots, and more riots than what you already know there have been in the past.
Yes. So she said, we're going to go out in the streets. We're going to increase the level of confrontation. This is after there's been all these problems.
So now, what it would be the move if you're the defense now? I mean, you make a motion for a mistrial.
I wouldn't start there. I would start with a motion to interview the jury, and separate from the whole group, and do it individually. They've done that throughout the trial process whenever an issue was raised by the prosecution. So just say, look, and just ask a general question. Have you
Have
seen
you
or
heard the
heard
news?
anything that relates to this case? Have you seen, did you hear anything about any statements being made this past weekend? Has that had any impact on your jury duties? And a follow-up that basically gets them to pre-commit that this will have no impact whatsoever on their verdict. And then you could proceed accordingly. If they all say that, okay. And if enough, all they need is 3 to come back and say, no, it's a problem, and you have a mistrial. And then you
Now,
request a mistrial if that happens.
I'm just reading this here. Michael Hughes says, if Trump was kicked off social media for advocating for peaceful protests, Waters should be criminalized for promoting these violent riots. It is, even what Maxine Waters had said in the past was over the top. At the very least, in terms of the respective rules that are applied to both ends of the political spectrum. If what Trump said was bad, and you can feel that it was bad, then this is bad as well. If what Trump said was not bad, this can still be bad, but it's definitely one level more specific than
because
anything.
she went right to the middle of the scene. Now, I'm not a fan of all those riot incitement laws or the rest. I think it's protected speech, what she said, but it just created a problem because the judge chose to hold the trial in that community, and he chose not to sequester them, and he chose not to order them not to look at social media. So he's created a problem that now has backfired on him. Now, I'm sure he'll go forward. He will not do a mistrial. He might interview the jurors. That's why I wouldn't ask for a mistrial out of the gate. I would ask for something more reasonable to interview the jurors, because they will be sequestered once the closing arguments happen. And that's what makes what Maxine Waters did so problematic. She chose to come up there the day before while they were not sequestered, right before they were about to start deliberations. And it's hard for me to believe that wasn't deliberate and intentional.
What does it take? Someone had just brought up the chat. If there's a mistrial, does Maxine Waters want there to be a mistrial so they can get another trial? Yada yada. Is it a mistrial with prejudice or without prejudice?
No, it's always without prejudice. Usually, the only time is with prejudice when there's government misconduct. But generally, they would just retry the case later on in a couple of months.
If there's abuse of government conduct, Maxine Waters is a member of the government. Could the judge, in theory, say? Could a judge say, if he wants to be, I wouldn't even say vindictive, how about just say, make a point? Maxine, it is because of you that there is a mistrial with prejudice, and so any uproar is strictly because of you. I mean, is that within the realm of possibility?
He could say that, but it's technically she's not part of the prosecution team, so there's not much the judge couldn't legally really do that. If he wanted to politically punish them, he would move the trial. He would say next trial happens in rural Minnesota. Because here's what I will say: from watching the trial, from watching other people watch the trial that were undecided or leaned guilty beforehand, that if this trial was held anywhere else in Minnesota, it would be not guilty verdicts across the board. And so that raises questions. There's going to be a shadow of surrounding this trial if there's any guilty verdicts because of what the prosecution chose to do. They could have presented a case very different than they did, and they opened themselves up to problems with those people who, again, many of them were leaning guilty before the case started. And in part because of the pushback against the media narrative and the prosecutorial misrepresentations. I mean, the prosecutor started out with their first witness proving they lied in opening statement. I mean, their opening statement was the police had to call the police on the police. And this witness will talk about how so shocked they were that they saw what they saw, and they immediately called 911 on the police. And the witness didn't confirm that at all. And it's like, man, I mean, I get you think the media lies because the media can get away with gaslighting the world. But as we've talked about, the media's narratives could never survive a real trial because then you have to have real evidence in front of a real jury.
And they're so over the top. All you can do is, even when the media is trying to preserve their narrative, they just talk about cherry pick and ignore stuff to report.
It's atrocious. NBC has an analysis of these law professors should quit practicing law. And some of these criminal defense lawyers should quit practicing. I mean, like one of them's analysis was the defense expert doesn't count because he's from South Africa. I'm like, you think identity politics plays with the jury in Minnesota? I mean, there's other issues, but that's one of the dumbest analysis I've read. Another one said, oh, there's just too many white people on the jury. It's a half minority jury pool, a jury. And then they did this, and I was like, this is not how people think. And if it's led to be acquittals, it'll be black men who lead it. which will create a cognitive dissonance like we've never witnessed before in the white liberal lawyers grandstanding on this case.
Here's a good question. I mean, it's a good question. I don't know. I think it's implausible or unlikely. Couldn't Maxine's comments be taken as jury intimidation or jury tampering?
Doesn't really matter because she's not really subject to those rules exactly. Mm-hmm. So in other words, it has to be, and I'm not in favor of that because I believe when they start anytime they want to punish speech under any pretext, it's always going to backfire. So even if it's Maxine Waters doing it, I think what she was doing was trying to extort a jury verdict of a particular type to defend the media's narrative on this, because George Floyd has hagiographic status within the media narrative. And they can't afford that this case be exposed to be something other than what they've been lying people about for a year. But I don't think it should constitute legal intimidation, because otherwise it will be misused like it was in the Roger Stone case. They said that you couldn't talk about juror bias, or that was jury intimidation in the Stone case. So I'm a purist when it comes to speech.
Well, we got Hipoopy says, wondering if they've been following Robert Gruler's daily summaries. There's no question. I think people are. The information definitely makes its way there. There's no question about that. And James
Gruler's an example. I mean, Gruler, deeply down, kind of wants to convict. Gruler doesn't hide the fact that he's not pro-cop. He's a defense lawyer. He's not bashful about that. But he's been pointing out early on, he's like, man, there's just reasonable doubt all over this case once you look at the evidence.
And Robert and I are doing a stream, or we're going to do a video with somebody from Diecast where we're going to review a movie. And I just over the weekend watched 12 Angry Men. Never seen it before.
Ooh, which one? The first one or the second one?
It was black and white. I think it might have been the 1954.
No, that was the first one. Henry Fonda.
It might have been the 1954 version. Either way, I made sure I saw enough portions of the other one as well. But I was going to say, like, in that case, I still think I would have voted guilty. But if that was reasonable doubt in that case, I mean, go ahead.
All you need is either reasonable doubt about whether or not it was reasonable force. And there, in previewing some of the closing arguments, what the defense can point to is the government's own experts acknowledged that he could have tased him. The government's own experts acknowledged that a neck restraint is commonly used and taught. The government's own experts acknowledged that it appeared his knee was actually often on his back, not on Floyd's neck the entire time.
They had that one moment where his toe was off the ground that the expert said, look, all of his weight has to be on his back. And, but you have a video that, it was quite obvious. They took one screenshot from, or a still, which could show one thing, but the video's out there for good or for bad. The entire video's out there. So
a great closing line would be to steal the one. I've been waiting on the right case to use it from Jerry Spence, one of his last ever criminal trials, where he said the government wants you to look at this case with only one eye, and it's the evil eye. And I was like, man, that's classic, brilliant visual imagery. And so on our locals board, vivabarneslaw.locals.com, I will be doing an example of explaining how a closing argument is part of the Barnes Law School series, using as an example the Snipes case, about how to do a good closing argument, use visuals, use language they're going to see every day, have a common theme, hammer away at certain topics, open big and close big. Don't come in weak. Don't go out weak. Grab them right away. Don't do the whole, oh, we're so glad you're here and thank you so much. Lame. Go in and grab them and then get them in the story and then close heavy.
I don't, based on my assessment of Nelson, I don't think that's in his style, but
no, he believes in it. The big other risk is he didn't give the opening statement that I think was needed in this case. And he's done everything to build up for closing. Everything's about facts and law. And he better pray he was really right about that jury, or lucky with that jury, because I think he got himself behind the 8 ball. But what he can do in terms of facts is he can say, is there reasonable doubt on whether or not reasonable force was used? Well, just listen to the government's own experts that said he could have tased him, that a neck hold is okay, that prone positions almost never cause harm, that prone position is a lesser level of force than a taser, which might have certain resonance with the jurors in the current context of Minnesota. And then he can go to part 2, that there's reasonable doubt. And he also got his own expert to say that for most cops, a prone position restraint is considered a restraint of control, not of force, because you're not shocking them, you're not hitting them, you're not shooting at them. It might cause pain, but so do handcuffs. So does isolating someone in the back of a locked-in car. If from their perspective, this is just to control them, not to hurt them. And there was a good cross-examination of that person, that expert, use of force expert on that issue. But they do have evidence to support their position. But then they can say, is there a reasonable doubt about causation? According to the government's own witness, he was dead, lead medical expert. Now they disagree, they're government's own experts. But the lead medical expert said he was dead about 5 to 6 minutes in. In other words, in fact, he times it so that when Floyd stopped resisting is when Floyd is dead. Well, if your problem with Floyd is his continued restraint, or your problem with Chauvin is his continued restraint of Floyd past resistance, well, according to the government, he was already dead then. You can't cause a death. Dershowitz actually won a case like this. He got a guy off who shot a guy in the head. And the way he got him off, he was like, no, the other guy shot him first and killed him. So that's how his guy got to walk. It was like, only Dershowitz comes up with this kind of thing. But it's the same kind of thing. And then, also on causation, they have the heart disease, they have the tumor, they have the high blood pressure, they have the sudden ingestion of drugs, they have the other drugs. So they have a lot of evidence on causation. And then on the third part of intent, the evidence is real weak. Do people really believe that Derek Chauvin, while on videotape, while on body camera, thought he was killing George Floyd? I just saw too little evidence. And then once they introduced the fact that this was a common training mechanism, that they introduced evidence that it was considered the least level of force you can use to restrain someone compared to other options and alternatives that the government's own witnesses said they could do, like tase them. And the other evidence that, in fact, it's very rare for this method of restraint to cause death or even serious injury. It's hard for me to not see reasonable doubt on all three, and the defense just has to win on one of the three.
Okay, now I brought up a few chats. We're going to get to all of them before changing subjects. Robert, do you know the makeup of the jury? I've been very curious about that. I forget the makeup. It was a diverse. It's a
unusually
diverse.
A typical Minneapolis jury would have 5 white men, 5 white women, 1 African American, and 1 Asian, and would be at least a third retirees. This jury is 6 African American or mixed race, 4 white women, and 2 white men. So the prosecution picked their jury based on demographics. 90% of Biden voters thought Chauvin was guilty before trial. They picked a bunch of Biden voters demographically. And the defense, on the other hand, focused on answers, substantive answers. And those suggested that some of the African American men were skeptical of the government's case. And that would be the right group to pick to argue back. Fascinating psychology of what happens in a jury room. So it's great educational learning, even if you're never going to try a case, even if you're not even interested in law. If you're just interested in the way the mind works and human conversation works and persuasion works. My view was going in that 8 of the 12 jurors leaned guilty, 2 leaned not guilty, 2 undecided. Based on what I've witnessed from other public reactions out there, I would say right now it was going in 8 presumed guilty, 4 now not guilty. But the big question is this, and normally 8 to 4 it goes guilty on something. Now the caveat to that is what happens, what we discussed before the trial. What happens if this is why if you're in the media or any part of any case, if you only put out your version of events and you're able to dominate that side of the aisle narrative structure, you're going to get misleading answers from people. Because if they don't know the full story, you don't know how they would react to that other information that's going to come about during trial. The question is, how many of those 8 people that said guilty were actually basing guilt on the limited information they had that now has been completely counteracted by the trial?
I'd say all of them. I mean, there's no question. There's no question. Everybody who would have leaned guilty was leaning guilty based on the tidbits of what we now know as being a part of the story. And we now know more of the story. You might still think they're guilty. He's guilty. But, okay, 2 things, actually, before we move on to another topic. Maxine Waters can be impeached for what she said? Forget criminal prosecution.
Yeah, of course. Yeah, I mean, because she's trying to interfere and impair and obstruct the criminal justice process, in my view. I mean, a great danger what she was doing. It was within her duties because she was doing it as a member of Congress. She can't be sued for it.
Yeah, I was going to say the sovereign immunity for sure.
Yeah, exactly. No, by the way, she's being sued for libel and she hasn't figured this out yet. So she didn't apparently timely raise the Westfall defense. So she's going to have to face trial for libel in California.
And
So,
some people say that
nobody's ever confused Maxine with a Nobel Prize intellectual winner, put it that way.
I was just going to say, some people now are saying Mad Max, they have to change the name because we have Maxime Bernier, who is the leader of the People's Party of Canada. He goes by Mad Max, and people don't like the association. All right, well, we're going to see. People are asking whether or not we're going to live stream during the
So that'll be tomorrow on Rumble. So I think that was the plan, right? On Rumble, live stream the closing arguments, and we'll give our commentary throughout the closing arguments as they go along and afterwards, and we'll see how good they are. The prosecution will now. Here's what the prosecution did well: lots of emotion, lots of appeals to authority, lots of visuals. That they did very well. The defense was all facts and law. We'll see if that's, in my view, a huge gamble, but maybe it'll pay off. But I think in terms of cross-examination, I thought the prosecution did a very good job of prosecuting the lead use of force expert for the defense, but that was because he had to take a broad position of saying that even that the prone position is never a use of force. I understand what he's trying to get at, but I think that's a tough sell to the jury, and the prosecutor was pretty effective at taking that apart. But otherwise, Nelson was a fantastic cross-examiner and really took apart most of the government's, got the government's witnesses, a bunch of them, to say stuff they shouldn't have said to help, that hurt the prosecution, in my view, that we'll probably see a lot of in closing argument.
Okay, so to be continued, and this is going to be a good segue into our next.
And that'll be tomorrow for everybody on Rumble. I think the opening statement should start by around, golly gee, I think 8 a.m. I think 11 a.m. Eastern Standard Time, I think.
Okay, and we'll see. I mean, maybe we'll try to run it on both. People who can't view it on Rumble without an account, we'll see what we can do.
Oh, that's true. Yeah, we'll try to have it available for both. But those who want it on Rumble, which hopefully will be there, and then here on YouTube, and we'll go from there. So, I mean, I think it's a great trial to learn from about how the criminal justice process works. And I think acquittals would increase confidence level of at least a large number of certain groups of Americans in our criminal justice process. Conviction, I think, will upset as many people as an acquittal will.
And the options are, for there to be a conviction, it's got to be all 12. For there to be an acquittal, it's got to be all 12. And if there's a hung jury,
normally speaking, if it's going to be a hung jury or a defense jury, it'll take a while. So if they don't come back next week at all, that means usually they come at a trial like this 3 weeks. You would usually expect them to take 3 days. So you expect them to come back probably Friday afternoon, so they can get home for the weekends. They never admit this, but a lot of jurors want to get home for the weekends, especially when they've been sequestered. They'll all week they'll have been stuck in a hotel someplace, and they don't put them up in the Ritz. So the it is what it is. So I think I'm hopeful they take their time. I'm hopeful they assure, and if there's a deep split within the jury, what tends to happen, let's say they come back and they say, we just, we cannot come to a unanimous verdict. The the judge issues what's called an Allen charge, which says go right back and keep doing it. And he'll usually issue that multiple times. And what tends to happen is usually holdouts fold. Unless there's more than 4 holdouts, they almost always fold. Now, sometimes they compromise. I was the victim of a compromise in the Snipes case. I had 9 jurors went across the board, not guilties, 3 holdouts, and so they compromised on a few small misdemeanors, or what should have been that from a sentencing perspective. But that's another story. But so I think if you see it, if they come back early, almost always means conviction. Particularly in a case like this, it will mean usually across the board conviction. But you may see what tends to happen is not like people are talking about a hung jury. Very unlikely. I didn't hear of anybody who was a holdout. Anybody that smacked of being a holdout was not picked for this jury by either the prosecution or the defense. So I think what is more likely to happen if there's a real big internal fight is a compromise verdict. You'll see a second-degree manslaughter rather than a third-degree murder or second-degree murder.
Okay. And if there is, in theory, if there's a hung jury, retrial potentially?
Oh, yeah. But I think then the judge will move the case. Particularly, I think Maxine Waters helped make sure of that. So, and then, I mean, based on what I saw, I don't see them convicting him outside of Minneapolis. I just, unless they change their theory of the case, change their strategies, change their prosecution methods, etc. But this, like I said, the case was a political case. They could have easily settled this on very reasonable terms and chose not to. Now, a lot of that's on Bill Barr, one of the most, one of the worst attorney generals we probably ever had in America. But his dad, by the way, just coincidentally put Jeffrey Epstein in the business. And remember, folks, eternal truth: Jeffrey Epstein didn't kill himself. But we'll see how the case goes. I'm hopeful that the jury does as good a thorough job, but they are under unusually stressful circumstances, and I don't know who would blame them if they come back with some compromise or even a guilty verdict under these circumstances, even if it's not what a conscientious jury would have independently produced.
All right.
My odds are still there is a betting market on this, by the way. Made my first cash betting on OJ being innocent because maybe he was, but that's for another day. Another case where the media narrative and the trial narrative were two very different things. But right now, the odds are 25% chance of all not guilties, 25% chance of all guilties, 50% chance of a split verdict. I would say before trial, that would have been that was close to my odds. I had 75% of something and 50% of everything. But now I would say the prosecution has made this an all or nothing case. They didn't have to, but they have. It's either death by Chauvin or death by heart disease or death by drug overdose. Only the medical examiner witness was willing to say it was a combination. The rest are like, no, it couldn't be those things. It couldn't be those things. I mean, they even went so far as to claim that the white pill seen and captured on photos in Floyd's mouth, later part of that white pill that shows up in the back of the police squad car with Floyd's saliva and DNA on it, partially digested, which was full of fentanyl, that wasn't what was in his mouth. No, it was either bubble gum or something he was eating inside the store. Why go there? I mean, these are things, again, it's because they want to prove the media narrative. Floyd is a hagiographic hero who didn't do anything wrong or make any mistakes, and any attack on him is a racist smear job, which is actual media stories with that headline. Defense lawyer is mean and cruel and is involved in a racist smear job. No, they're just exploring what the cause of death was. And that Chauvin was, of course, totally bad and horrible. And not that there's a big in between where lots of people made mistakes, and what actually was criminal and culpable is up to the jury to determine.
All right. Well, to be continued for sure. Bridging into another story where the narrative of the media may not pan out to be reality. Ahmaud Arbery. Everybody knows the story. It was the McMichael brothers who spot someone who they think
son and father.
Yeah, sorry, son and father who spot someone in someone else's neighborhood. What they say was scoping out a place, checking out a building under construction. They were suspicious. They started tailing him in a pickup truck, armed. When they tried to put him under citizen's arrest, Ahmaud Arbery grabbed the gun of one of the McMichael's son. Ended up getting shot, dying, and McMichael, son and father, charged with murder. And the initial story coming out of the media was Ahmaud Arbery was out for a jog, and you can't even jog in the country. I think you were particularly critical of LeBron James for his
jogging
tweets
while black, and he was killed for jogging while black.
Now, now I know what I feel about this one, and I've been saying it from the beginning. So whether or not he was jogging, I say, even assuming what they say is true, this is not the way things should go in a society that doesn't fall apart at the seams. But in the case now, the news is that the McMichael's brothers, the McMichael father and son, have filed a motion to disclose or to add additional evidence. And all of the evidence is a series of past conduct by Ahmaud Arbery, other incidents, criminal in nature, suspicious in nature. And it's a 9-page document. I think there's close to like 10 or 12 incidents that they want to bring in as evidence. One of which is carrying a concealed firearm to a sporting game and gets chased down by the cops. Another one where he was scoping out a place potentially for stealing from it. Another one where he was involved in a violent attack with wire cutter, et cetera, et cetera. So this motion, I've never seen this motion. It looks, to someone who doesn't know better, and I'm including myself there, it looks like what they're saying it's not. In the motion, they say this is not an attack on character. This is trying to prove elements that are going to be relevant to explain what happened that day. To me,
it's modus operandi evidence. And so, similar to what came up in Floyd, how much of Floyd's past could come in, particularly his 2019 arrest. and it's the degree to which it's common. And so the idea is that they're not introducing the evidence to show he was a bad person. They're introducing the evidence to show that he had a pattern of comparable conduct that made their interpretation of his conduct reasonable, because objective reasonableness can be a factor in a wide range of self-defense or citizen's arrest context. And so what they document is it's what we talked about, what I said at the time, which is I said, I'm sorry, I didn't buy that he was out jogging. I said that doesn't necessarily exculpate the father and son, but I said the idea that he was shot while jogging is nonsense. That in all likelihood he was casing out properties under the guise that he was jogging, and that there was a lot of inferential reasons to believe that, and that has turned out to be absolutely true. He apparently goes out jogging and then cases places and breaks into places repeatedly, and had done so at least more than a half dozen times in the incidents leading up to this. He also, it turned out, was the guy in the house months before that the son had seen, that the son had called on. So, this wasn't architectural viewing and and again, these are some of the ludicrous explanations and excuses the sort of BLM media narrative is, rather than just saying maybe the guy's conduct is wrong, the father and son, without saying, oh, he's this nice, choir boy who just likes to jog and look at houses under construction.
It is the problem, because in my mind, and I've said it from the beginning, it wouldn't change anything in my mind. But when people discover that they have been so misled from the beginning, it's going to change something in their mind, and there's almost a risk. There's the risk of the backlash, where you're treating people like they're idiots by saying he was, literally, he was out for a jog. And then he came across a building under construction, and he's got an interest in it, and he decided to go see the building under construction. There's nothing wrong with that. And at some point in time, you might be inclined to believe them until you realize you've been lied to over and over and over again, as seems to be the case this time. I think people might get angry with the statement. I think that original narrative has crumbled. I don't think that narrative stands.
Completely. So, now, there's a lot of bad evidence about the father and son. I mean, there's some evidence on the son in particular, a lot of racist statements, some other things.
Apparently he made a racial slur as Ahmaud Arbery lay on the ground, dying. And I've said it from the beginning also, this is not how things should be done. I don't care that you have the right to make citizens arrest. If the guy's burglarizing the neighborhood, you call the cops so that it doesn't end this way. Effectively, it doesn't end this way, regardless of whether or not.
But there'll be more of this if we start defunding police and police are scared to enforce the law. Part of the reason why that happened was inadequate police responses to prior burglaries in that neighborhood. And police calls in that neighborhood.
Well, there's no question about that. And then you get into the situations like Kyle Rittenhouse, where police are not doing what they need to do, and then you need literally people to do it for you. In the McMichael's case, now, having read that motion, and it's divided into two pieces. I might do a video on it just because it's interesting to go through, but the motion reads, I don't care that they say they're not victim blaming or they're not attacking, impugning character. It reads like they are. I read it and say, okay, all of this may be fine and well, but they knew none of it. They thought he was casing the neighborhood, but they knew none of his prior violent arrests. They're going to say, yeah, but that explains the way he reacted to being put under citizen's arrest, and he tried to grab the gun, and therefore, it explains what happened that day a little more. It's going
to be a lot like the Floyd analysis of the prior arrest. So it's going to be, how much is this relevant? How much does the Arbery state of mind, how much of that is relevant to some element in the case, such as, say, objective reasonableness? So like in Floyd's case, he only introduced the part that showed that Floyd had previously, when under arrest, done a sudden ingestion of drugs to prove that fact. Now, the prosecution could mute all this by not pursuing Ahmaud Arbery as the sweethearted kid who just likes to take a jog, who these crazy people chase down. But they, of course, a lot of these cases, they can't help themselves. I mean, we saw tons of evidence of that there's a Minnesota evidentiary predicate that allows them to bring in that kind of thing. But I think it's very problematic. That the person is perfect and so on and so. This was a big mistake in the OJ case too, by the way. Trying to portray Nicole as this perfect person backfired on that jury pool. So but I think it depends. Not everything will come in, but what may come in is anything that shows modus operandi that's relevant to the objective reasonableness and to the degree the prosecution is contesting it. So, I mean, like the only reason why the 2019 arrest came in Floyd's case is because the prosecution would not concede that he possibly had sudden ingestion of drugs, even though they found the drugs in the back of the squad car and in his toxicology report. So they could have avoided all that by just saying, well, and just go with the medical examiner, but they didn't. So the prosecution will have a lot of say on whether or not that evidence comes in. But my guess is some of it will, but not all of it will.
I say the prior scoping of joints, even that they're going to say, okay, so he had done it in the past, doesn't explain anything now. It might explain the frame of mind. That was the only one where it might explain the frame of mind, where McMichael's son says, we've seen this guy in the neighborhood. So,
well, the other part is interpreting the reason. In other words, we can't know fully what the McMichaels thought or saw. And if they're saying, look, he's behaving like this based on our behavior, independent confirmation that he had a history and habit of doing so potentially could be relevant, especially if objective reasonableness is a component. It really depends on what elements there are and what the prosecution is willing to stipulate to.
And who's the judge in this case? Do we know who the judge is that's going to hear this?
A local state court judge. The prosecutor's been brought in from out of town, so he's a political guy. So they've already tried to get him kicked from the case unsuccessfully.
Okay, so they'll succeed. They'll get something of it, not all of it. Everyone's win-win, and
they may get none of it. But usually they introduce something if they can show go to some element of fact that the jury is supposed to determine in the case, which sometimes only the other person's state of mind can be relevant for that. But it definitely becomes relevant if they want to make Ahmaud Arbery, if the government introduces character evidence on his behalf, then they open that door.
The way I read it, it looked like an overreach. They were asking for a lot of stuff, some of which was only incidentally, potentially tangentially relevant. I wouldn't be surprised if a judge says it made it look weaker by asking for everything than just picking the three most potentially relevant things. If I had to guess, based on what I know from here, it's irrelevant, but I would say they might get nothing, and but it does depend on the judge. What's the time frame on that? I mean, do they schedule a hearing for it, and is it going to be a big issue that we're going to hear about, or does it go by relatively
the media won't talk about it at all, because the media has been totally silent about this. So it's only the people that are tracking the court docket have even come across this. It's extraordinary the stories they will tell and they won't tell, because Ben Crump, who magically shows up in all these cases, which is a good transition to our Dwayne Wright case.
Yep,
Ben Crump was out there telling people this weekend that he was shot for driving while black. That's completely false. I mean, you could have lots of problems with what the police did. He wasn't pulled over because he was black. It was a black police officer who was involved in the lead on the case. He was pulled over because he had a vote, because problems with his registration was out of, just word to the wise. Other than always in cash and never in writing, if you're on the lam and you have an outstanding warrant for a crime and you decided to skip court, don't drive in a car with license plates that are past their registration date. Just advisable. So that's why he got pulled over. And the only reason why they tried to arrest him was because of the outstanding warrant that they flagged. And what's interesting is this. Contrast it to the Floyd case. They could have used a lot more physical force on him. Instead, the cops being like, real careful, move your arm here, letting him be right by the door, trying to use no physical force at all.
Let the memes in the chat begin, Robert. Yes. Oh, by the way, we hit 10,000 again. So comments and thumbs up so that we can get those numbers up. Not that it matters. I just hitting 10,000 on a live stream is a very beautiful feeling. Actually, it's a lot of people getting a lot of information that they're not getting elsewhere. And I'll just go over Dante Wright, because some people might not know, and I don't want to make the what was the mistake the Barstool Sports mistake again. Dante Wright, it's been the most, the biggest incident in the States now. Driver pulled over for expired plates or expired tags. He had an outstanding warrant for, I believe it was armed robbery, and had breached his parole. He was out on $100,000 bail, I think. Bail.
Yeah, he didn't even show up for a Zoom hearing. It was a Zoom hearing. He didn't even show up for that.
And he had stopped contacting his parole officer. So serious stuff.
Oh, it's probably the pretrial services. Well, it may be called parole, but it's basically his bail officer.
Okay. And
he hadn't been convicted of anything yet.
Okay, good point. My apologies. And what I was going to say, I presume the cops know this very quickly once they pull him over, like once they run the plates, or how quickly do they know?
Or I think it may have been his driver's license.
Okay. So
they pull him over. They discover the outstanding warrant. They're going to take him in. They're being real gentle. Only one cop is using any force on him. And so what happens when there's one handcuff put on one wrist? He breaks free, jumps in the car, tries to drive off.
And the female, her name was Potter, Kimberly Potter.
Yes. So she sees that and says, "Taser, taser, taser," fires the weapon. As he drives off, the car crashes. Yeah. She turns to him and says, "Oh my God, I shot him." So it appears that she didn't know that she had pulled her gun instead of her taser.
So, I mean, those are the facts. And she was swiftly charged, I believe, with
second-degree manslaughter, the lowest charge against Chauvin.
Okay, now, so I said in my analysis, I said, look, I don't think many people can disagree with the charge being brought. Now, I know people take offense to that or take exception to that.
I would. Actually, Dershowitz does. Dershowitz finds it an absurd charge.
Okay, but now, so this is the deal. I read through the statute for second-degree manslaughter. You have someone admitting in real time, oops, I made a mistake. I pulled out the wrong weapon and killed a man effectively. So, I mean, how is that on its face? It's a contemporaneous admission of having made a mistake that led to the death of an individual. Now, the question is going to be, was it an egregious enough mistake? Was it negligence in the sense of second-degree manslaughter or not? This is where I guess maybe I don't understand things. In order to bring charges, you have to have probable cause, which is more. Is it a higher threshold than what you would otherwise expect to be the beyond a reasonable doubt on conviction? As in, do you have to be certain of the underlying act in order to bring the charge for probable cause, or do you just have to have enough of a basis to think that the infraction was committed?
You just have to have probable cause, which itself is a low standard, but you have to believe as part of that probable cause that you can prove your case beyond a reasonable doubt to a jury. So it's a combined analysis. So while probable cause is a low standard, what it's evaluating is a high standard.
Okay, now that clarifies the fuzziness in my head. So probable cause is, are the elements there? Do they prima facie appear to be there? But do you feel confident you can prove them beyond a reasonable doubt on the merits? Now, Jonathan Turley had written an article where he had gone over, briefly referenced a few other cases where under similar circumstances, people were in fact convicted. So, I mean, on its face, you have her admitting at the time, I made a mistake, I just killed a guy. I mean, how does not on its face justify probable cause to the point to at least bring charges? And if there's a valid defense, which we're going to get to in a second, she'll make it on the merits. So it justifies the charges, but not a conviction. She'll have her trial.
The reason why Dershowitz has doubts about it is the same reason the New York Times detailed, which is in the 20 plus cases of this being documented to have happened in the last 20 years, they have only chosen to prosecute, I believe, 3 times. Now they've convicted in 2 of the 3, but basically they rarely indict. And usually they only indict when they don't believe that they had when they don't believe the cop story. So here's what it boils down to. Do you believe you can convince a jury beyond a reasonable doubt? There's typically that she deliberately fired her gun. If, on the other hand, you think that she really was trying to fire her taser, then the level of culpable negligence criminally in Minnesota, like most places in the states, requires that you believe beyond a reasonable doubt and can convince a jury thereof that she believed at the time she pulled her weapon that she knew there was a substantial and unjustifiable risk of death. So it's not like straight negligence. We don't really have any negligent murder crimes in America. We require higher mens rea. So that's the problem. If she really thought she was pulling her taser and firing her taser, then did she think that there was a substantial and unjustifiable risk of death when she pulled the trigger? So in my view, you would only go forward with the case if you think that she's lying about that she just planned on shooting him. I think it was a case of bad negligence, but not a case of criminal culpable negligence, because I don't think she had the mens rea that she thought what she was doing would likely kill him.
I mean, or the argument is just that it was so sloppy and she was so bad. I mean, some people said, okay, she shouldn't be charged, but she should be disciplined and fired.
Yeah. I mean,
But
that's
the
normally
question,
civil
the
remedy.
question is if it's just such an egregious mistake, pulling a taser, pulling a gun, thinking it's a taser.
Now, what's interesting here is the politicians deserve a lot more blame than they're getting. So for many years now, taser companies, it's Allison Morrow's husband, Lynn, was talking about this. And we interviewed Allison last sidebar.
Yep. And Allison actually, I mean, just for the context there, Allison did a News with Booze with Eric, where she had her husband come on afterwards and another guy, forget his name now, where they discussed this very thing. It's worth watching on Eric Hunley's channel.
Absolutely. Great breakdown of that case, breakdown of the multiple other cases, the Virginia case, other cases that have been taking place recently. I mean, because Lynn teaches people on use of force and training. And there was, but the problem, I was curious first, and then I saw that the local police department there decided to get tasers that look just like guns and feel just like guns. In other words, they're black, they're shaped the same, that the feel is the same. It's like, who came up with that idea? Now, maybe they have some explanation that I don't know about, but instinctively, because I thought the taser is supposed to be a totally different color, totally different shape, so it logically helps reduce the risk of that mistake occurring.
And it looked so realistic that when I saw the video, I didn't appreciate that I was looking at the video of the police officer who shot. I thought I was looking at the video of the other police officer, and it was the other cop from across who shot, because what I saw in the person's hands, I was convinced it was a gun, not a taser. That's a ridiculous thing in my mind. I don't know. I mean, I've never been a cop, never actually held a taser. But to me, they should look more like, flashy yellow things that are held more like an actual taser.
They're
and
totally weird shaped that will trigger a muscle memory different. But again, you could make an argument that this all happened because this is what happens when the police react to things like the Derek Chauvin trial. They're like, okay, we better not use any physical pressure. We better just go to the taser. That's much safer. And as the other expert talked about on Eric Hunley's Unstructured podcast, you can also get at Locals, Unstructured. Unstructured.locals.com, was that there's an inherent risk with tasers, that maybe they're a lot more risky than people think. And it was an intriguing debate because Lynn made a good argument that if you can train people to handle military service very well, you can train police officers. The other person, who was a former police officer, said from his experience, we're expecting way too much, that these kind of mistakes will happen in a crisis moment. And that's a good question. I have doubts that she's guilty of criminal behavior. I think civil recklessness, write a check, be fired, all of that, some reform and train. The big reform is don't buy tasers that look and feel like guns. Start there.
That seems like a no-brainer. And it's even, I don't even understand why it would be that way in the first place if there's a functional aspect or whatever. Now let's contrast this, because some people disagreed with your take, about comparing it to Ashley Babbitt, where you have that situation. People don't agree on the facts on that situation, which is where I think a lot of the disagreement comes from, is people don't have a consistent understanding factually of what they're all prepared to agree actually happened. But you had the riots in Capitol Hill. You had a bunch of protesters banging down, breaking windows to try to get into a room where there were politicians. And there was security behind the door, apparently issuing warnings not to come in. Whether or not Ashley heard them is obviously up for debate, but Ashley's climbing over a table to get through a broken window, and there's a cop who fires point blank live round into a crowd with police officers behind Ashley, and with a crowd of people, had issued warnings and whatever, and was protecting politicians, whatever, and one round kills Ashley. And then the question is here, they investigated and they brought no charges. So the question is,
won't even disclose who it is that did it.
That's what people were. I don't want to mention the name if people seem to think there's a name, but I thought they had identified the police officer, but then the meme or the
running officially. People have tried to guess at it in the private media space, but there's been no official acknowledgement whatsoever.
Okay, hold on one second. I've been told that I have a light behind me. Hold on one second. There was a light flashing. Okay, let me get back into focus here.
I mean, it was summary execution for trespass. Compare it to the Minneapolis case. I mean, to my knowledge, his excuse wasn't that he thought that was a taser. So we didn't hear that from the Justice Department. And I mean, like people are saying it was okay because it was justified. I was like, hold on a second. We don't have summary execution in America. The police officer doesn't get to at least of all for trespass and damaging property.
Well,
that's less.
The argument is going to, for anyone the argument would be this armed police officer has guns drawn, is defending politicians. They're trying to break into the room with politicians. In comes someone not defying whatever orders may or may not have been given. I thought there were orders. People are going to disagree on that element of fact. See someone come in with a backpack on, doesn't know what they're up to. I mean, whether or not the reasonable escalation is what it went to, highly arguable. But I say that,
like, how did that contrast to say someone's out on armed robbery, has skipped a bail, is in a car, is about to take off with someone else, and may have a gun. I mean, if you can't shoot that person, then why can you shoot Babbitt? That's the part that I was like, there's just complete inconsistency here, contradictory principles here. We got to have one standard for use of force, not multiple.
Or people are going to say when it comes to politicians, it's a different standard. It's
I mean, that's what it appears to be. It appears to be a politically motivated decision that has a completely different standard based on whether you're a line cop or versus in a Capitol Hill police context. And so, I mean, the other problem was they didn't release a lot of evidence because, as you note, there's contradictions out there in the evidence as to whether she heard anything. No, there are other people that have tapes that say, no, you can't hear anything. You can't hear a single warning on the tape. And it is a little freaky. You see the gun just sneak out, bam, pull back. You don't, I mean, I expected to see people step forward and say, everybody back, here's the gun, boom, boom. That never happened. They just snuck in and bam. And maybe they gave some sort of warning. But again, there's evidence that such a warning wasn't in fact heard, at least by other people that were near her. And there was a complete lack of transparency by the Justice Department. They didn't go through, compare it to the Michael Brown case, where the Justice Department issued like 100-page ruling as to why they weren't going to get involved because the evidence was overwhelmingly against prosecution in that case. Compare that to this, where there's almost no evidence given. And Technofog, who does a really good analysis on Substack and other places, he said that the Department of Justice analysis was completely bogus and contradicted prior prosecutions that they had brought. So my view is, at a minimum, I'm not a big fan of prosecuting everybody for every conceivable reason, but we deserved a much more thorough and transparent set of information than what we got. Maybe there's an explanation from that officer that is persuasive, consistent with the evidence that shows why he believed it was necessary to use the force he did. But the message that comes out is, if you're on the wrong side of the political line, we can shoot you down and there ain't nothing you can do about it. Whereas if you're on the wrong side of the political line and we don't like what you did, then we can railroad you and legally lynch you. So it's a dangerous sign that our justice system is sending to people.
All right. With that said, we're going to move on to what do we want to move on to?
Well, speaking of different forms of sort of gaslighting that's occurring, the attempt to remove Project Veritas and James O'Keefe from all known existence in the social media space.
So they came for Alex, and then now they're not starting. They went after Trump, and now you got to get the people who have the influence. So everybody knows about the most recent expose, Project Veritas, James O'Keefe released. You could interpret it the way you want. I mean, basically, I don't think it gives you anything new. It just gives you the words and it gives you the images to go along with what you always knew. CNN is pure fear-driven, politicized propaganda. They're not news. They are just pure propaganda. And so James O'Keefe has some undercover stuff with he was a technical director, the individual they got on camera, apparently on a Tinder date, from what I understand. And, basically going on about how if it bleeds, it leads. It's an old expression. Everybody knows it. CNN was, running those numbers to hype up the fear, hype up the drama, good for ratings, using it as verbatim, quote, propaganda. We all knew it, but now we could hear it with our own ears. They release this expose, and what ends up happening? They get booted from Twitter, or James O'Keefe gets booted from Twitter, and they may have again raised multiple justifications for the removal, but one of them is alleging that James O'Keefe, who himself has an unverified account because Twitter won't verify him, the allegation is that he was using multiple accounts to promote the stories and to game the algorithm or game exposure, whatever. And so they kicked him. They permanently suspended him, to use the Orwellian term. So he's now announced he's going to sue. And I mean, it's an interesting question. It's we've now seen the door open a crack to this. Robert, have I missed anything? And what do you think of it?
No, I mean, I think it's also interesting that this happens after he succeeds in suing the New York Times, which caused a lot of political and public embarrassment for the Times and the institutional media. That all of a sudden he exposes CNN. There's talks that what he disclosed could be used as evidence against CNN and other libel cases, and including Project Veritas's own potential libel cases. And that's when Twitter comes in and basically completely memory holes him from Twitter existence. And this is while Twitter has been caught, lying about the whole Hunter Biden thing and why they suppressed that information. Well, by the way, remember Twitter's excuse, Hunter Biden case. Oh, we think this may be hacked materials. We can't allow that. Wow, Twitter is promoting right now openly hacked materials that disclose the donor list to Kyle Rittenhouse. Shows what complete frauds Twitter is, just in case there was any doubt about it. They were part of the election fortification that happened this past election.
No, but there's no doubt. It's just that, like, people who don't care will never care. People who don't want to be convinced will never be convinced. And you just have to hope to get to a 5 to 10% of the people who genuinely care and might not be aware because they don't watch Viva Barnes every Sunday night.
Exactly. Well, and it's going to go, his grounds against Twitter is the case we talked about in Florida, the Hunter Biden laptop guy. Because what Twitter is starting to do, it's the same grounds that Bobby Kennedy potentially has, which is that now social media is no longer just removing people from their platform. They're lying about them for the excuse for removing them from the platform. And the fact that of the lie is being propagated as further reasons to isolate and marginalize them. And we saw what that was all about in the New York Times suit, where the New York Times was relying upon what other media people did to say that James O'Keefe and Project Veritas couldn't possibly sue them. So and that's what he's going to sue on. And so he hired Harmeet Dillon, who does a lot of great work. I work with her firm in a range of cases and contexts. She did a lot of the really good church cases that went up going to the Supreme Court, getting good vindication against the lunacy of the lockdowns. And so I think he'll have a pretty solid case, and he's proven himself able and capable.
Well, that's what I was going to say. It's like, we know it's an uphill battle. I don't think it's a lost cause. There's been some precedent, at the very least, set in Canada for being able to sue them for defamation as a non-user or as a non-account. But James O'Keefe and Project Veritas, I've been following them for years now, and their lawsuits, they're pretty good in what they decide to go for and what they decide not to go for. And this, it's interesting. It does seem like a genuine mistake that Twitter made in terms of offering this as a reason for which, but who knows why? All the more so given the fact that when it's an unverified account, I mean, how do you even verify that information? They deliberately go to the way to penalize him by not verifying him, and then purport that he's operating other non-verified accounts as if that's something he would do. Maybe they have the evidence, the ISP addresses or whatever, but
he has no need to do that.
I mean, that's
his stories trend all on their own, despite all the algorithmic manipulation that goes on. So so I think he's got a solid claim. So we'll see what it looks like when it's actually filed. But, his win against the New York Times puts him in a new space. And I'm glad to see he has recognized the importance of bringing selective legal cases to enforce constitutional rights in these contexts. And he's been one of the leaders of doing so.
Well, I'll be covering it. The only question is going to be, are they going to block the links to that like they blocked the links to other things on social media, not allow people to even discuss the lawsuit, calling into question their behavior? So we'll see. To be continued for sure. And with any luck, we'll be able to get James on a sidebar with us. They've been using, I noticed they had some flash clips of me and some of their stuff. So I've reached out. Well, maybe I'll reach out a little harder this time. Okay, hold on. Let me just get to the list. It's going to be an amazing thing because Project Veritas, love them or hate them, they file good lawsuits, and they're well drafted, and they are on point, and they're well researched and well presented, and they're not like just throwing spaghetti against the wall type thing.
No, they're very good at what they do, and that's sort of another sort of novel precedent-setting potential suit has been brought, which is the first challenge to vaccine passports and mandatory vaccines.
So an interesting lawsuit. It's a few months old now. We don't really need to get into the details of the lawsuit, but it's a federal employee who was basically, told you're going to have to get vaccinated and not given an option as seems to be required under law. Filed an injunction to prevent himself from getting sanctioned or fired for refusing the vaccine. thus far has not been fired or sanctioned, but the question is going to be, can the state, as a precondition to continued employment, compel a vaccine?
And what's interesting is it was not long after he filed suit that suddenly they said, "Oh, we're not going to fire you or do anything bad. You don't need a temporary restraining order." So just the act of filing the suit appeared to change the mind, at least temporarily, of his employer. It shows the potential utility of doing that, but it will be a precedent-setting case to test the limits of it, particularly as we see more and more and more pushback. Wisconsin struck down additional components of the lockdowns in Wisconsin, again, for the failure to utilize the legislative branch, but still a useful part of all of this. The recall is going forward in California. You have criminal investigations of the governors of New York and Michigan that are ongoing. You have foreign jurisdictions that are pushing back. And as you started off the show with, even the Ford, the sort of honorary George W. Bush of Canada, in terms of his IQ, even he had to step back from his insanity because shocked at the blowback he got from usually quiet Canadians.
Yeah, they're still quiet, and there's still a lot of people who are, social media supporters. All that I know is I talk to a lot of people. I get a lot of messages, and I have discreet conversations with friends, family, and neighbor. I know people who are left, who think this has gone too far. And someone had said to me, how do you stay positive? Or there was a comment on my video from yesterday. How do you stay positive when things seem to be getting worse? On the one hand, the big ship takes time to turn, but when it turns, it's an unstoppable turn. We're getting to the point now where enough of the people who have been supporters of these measures because they didn't think they went too far have to see them going too far before they start calling them into question. And we're seeing it. But the question on whether or not your employment or continued employment or the conditions of your employment can be predicated on a vaccine, Robert, people are going to say, without getting into the debate as to whether or not it's a vaccine, people are going to say there are certain jobs, there are certain things that have always been predicated on vaccination or proof of vaccination. Travel to certain countries, admission to daycares, admission to certain schools. So people are going to say, well, it's been the case in other circumstances, so this is just an extension of it, and it's a pandemic. In this particular case, was it a federal law that was at issue, correct?
Well, not a law, but a federal employee. So it was good. His local employer was going to require it. His particular federal employer was going to provide it. But there's two issues with it, and this unique to this context. One is because this is an emergency vaccine, there's other restrictions on what they can compel. There's not only religious exceptions, but other exceptions you're supposed to utilize. But I consider the ADA framework very useful here. That the other examples you cite, that usually they can say it's reasonably necessary for whatever that is. In other words, we're not going to allow travelers to come here, I guess, unless, of course, they come across the border illegally. But putting that aside for the moment, we're not going to allow people to travel to a particular place. We're going to condition that access on taking certain vaccines because that person traveling in has no right to be in that country. Similarly, in the case of, say, childcare, part of their essential services is pitching that all of their kids are vaccinated in order to be able to get kids to utilize the service in the first place. The problem is in a lot of these other contexts, it's not clear that the ADA standard is being met, that there's reasonable necessity and no alternative. Because, for example, a lot of people could work in an environment that don't pose any risk to other people. So the ADA, what it requires from an evidentiary perspective is substantial evidence that's pretty clear that the only means you can employ this person is with, say, the vaccine. Otherwise, you're not supposed to discriminate against them based on a perceived disability or health status, which is really what the ADA is all about. So I think it's a promising start, and I think we'll see more cases like this if they go forward. But we're already seeing the degree of pushback is causing a wide range of governments to reconsider how aggressive they were willing to be out of the gate initially.
Well, this is an interesting thing just from a political perspective, without no judgment, just political. The harder the government pushes, the more resistance it creates. And in Quebec, there's been a substantial amount of pressure in Canada, discussion about vaccine passports in Quebec. And the government is now seeing they have openings for vaccination appointments that are not being filled. And it's an amazing thing is that the harder the government pushes, the more draconian they come with their threats of a vaccine passport. It doesn't induce compliance. It actually promotes resistance, which is counterproductive, and people should, probably see that from a political perspective. So I'm just curious as to see what's going to happen, because we've heard Dershowitz, we've seen you and Dershowitz duke it out. Whether or not in the ideal circumstances it could be compelled is one question. Whether or not in these circumstances it can be compelled is entirely another. And that's what we're going to have to get into, the actual nitty-gritty facts and expert evidence of any case, if it goes the distance, to set the precedent specifically for this, which will probably end up being just broad principles that are going to be established that may or may not fit the specifics of this case, but to be continued. But the one thing that we don't want to forget, speaking of pushback, free speech on campus, University of Virginia expelling the med student Bhattacharya because in a Q&A panel on microaggression, after the panel, there was a Q&A discussion, and he pressed one of the teachers, or a few of them, for about 5 minutes on what constitutes microaggressions. Do you have to be a member of a marginalized group in order to be a victim of microaggressions? There was a debate. There was some pushback. The school, there was someone who had organized the event, a urologist, a professor, filed a professional concern card about the student with the faculty because they didn't like the way this student was aggressive and argumentative with the staff. It was unheard of and just discourteous. The university did nothing shy of a Kafkaesque investigation, psychological torture of this student. They told him to go get counseling. Then they required him to get counseling before coming back to school. Then they expelled him and said, you can't come back until next year or whenever unless you get counseling. Then when he's out, they get a non-trespass order from the police without telling him why. And apparently these are not just allegations. This seems to be the facts established, or at the very least, the facts in the judgment. The school then moved to dismiss on a Rule 12b6, failure to state a claim. The kid had filed a claim, the lawsuit, on 4 bases. One was violation of First Amendment rights. The other one was conspiracy. There were a few weak claims in the case.
They were just antagon. The free speech claim was what it was all about.
Well, but my question is this: so the conspiracy to interfere with business perspectives was dismissed, but he can proceed on the First Amendment claim, and he can proceed against some of the faculty personally. My question was: is there not any charges that he could have gone with, like psychological abuse, harassment? I mean, a First Amendment violation for what they did to this kid. The other charges, I thought, I don't know the law on them in any meaningful depth, but they did seem like stretches. But it sent like they wronged this kid in a much greater sense than just a First Amendment violation. And I was surprised there was no claim for damages, psychological abuse. Could he not have included a claim on that basis?
He could have, and at least as part of the harm from the free speech violation. But it's just not a usually recognized harm for free speech violations. And it's generally tough to prove due process violations against campuses. They give campuses a ridiculous amount of deference. They're only started to push back on all the insanity from the sort of campus rape moral panic that was creating all kinds of due process violations for a substantial time period, probably going to come back. But so generally it's tough to sue on those grounds. Free speech is usually the only grounds. But it was fantastic that he was even able to survive a motion to dismiss, which he'll get into discovery, get into a lot of information, probably show that it was pretextual, as he alleged.
Can you imagine what he's going to get by way of internal correspondence among this staff? First thing first, Bhattacharya, he's of Indian descent or East Asian descent. He is by their own standards a member of a marginalized group in North America. If you go by these standards, that image of him walking into the meeting that was convened to discuss his enrollment status, for which he was given 3-hour notice. You look at the faces in there, and it looks like it looks like people who are there to psychologically torture you. And
a lot of these people are deans and high-ranking administrators. I mean, I dealt with this in law school. Everybody that was the main reason for the burgeoning, exploding cost of tuition in the United States is because of all these bureaucrats that we've been hiring, not because of teachers or anybody else, not because they're helping students meaningfully. And it's all these bureaucrats are all a bunch of wokesters, and they justify their job the more wokester BS they come up with and nonsense they come up with. And that's what you see a bunch of. I dealt with one in law school, just a total nitwit. Won't call out her name, but man, she was. But so it's great to see him sue. But it shows the insanity of it. And here's the real danger: they're starting to take what they're doing in educational institutions. They're extending to professional licensures, and they're starting to define medicine as having the right views. As you can't really do your job for your patients and understand them unless you have the right opinions.
Well, and I'll tell you from experience, I've had a lot of doctors who were the biggest a-holes on earth, but they're still damn good doctors. And this idea, I mean, that the pretext was that he was argumentative with the staff and confronted them with contradictions, apparently, and they're worried about what could be his behavior on the ward. This is a med student who's a young kid who's and his correspondence. When I say, and we've said this before, draft everything as though a judge is going to read it one day. Every correspondence coming from this kid to the university was actually drafted in such a way that it would be very difficult to interpret it with malice, where he says, is it normal that you give students 3 hours to prepare for a meeting to discuss their enrollment? And, and his response to them saying, we didn't like the way you talked. And he says, I was very glad they gave me 5 minutes. I enjoyed the discussion. It didn't even read sass or snark when things can so easily be read as sass or snark. This kid sounds like he has a great mental framework. I may be biased, and call me that if you want, because I think this kid was wronged hardcore from what I read. And the staff looks like they were out to punish anyone who would dare defy them publicly, because it's no greater shame than having your views questioned. But I wanted him to. I wanted like $1 million in damages. What sanctions can he get for First Amendment violations? Is it declaratory judgment, nominal damages?
They've delayed his ability to get medically licensed. So, I mean, the main thing is he's protecting his medical license by bringing the suit so that they can't use this against him later on to get that medical license. But the second objective could be the financial damage to the delay of his medical licensure. So, obviously doctors make a lot of cash. So you look at that, that's probably a decent amount. So but I think he's doing it mostly on principle grounds. He seems to be that, he kind of seemed aware that this process could be kind of crazy, would just try to assert his rights. And if it went AWOL, he would protect his rights. And he seems to be that kind of individual, though I don't think he was out to create this situation. That's for sure. And I think he himself was semi-shocked at how insane the process has become.
Now I see the flashing light above my head. Too bad you're going to deal with it for 9 more minutes. I'll keep my head up. No, the one thing where I was sensitive to is that the school alleged that he had made intimidating or threatening comments on social media without providing them. And so, I can understand. People go to social media and they say something jokingly that doesn't translate as a joke, but the fact that they didn't provide that leads me to believe that it doesn't exist. The school would have provided that somewhere in the correspondence.
Their definition of intimidation. I mean, I dealt with it in law school 20 years ago. So I had a case where I was part of a public interest project where I believe my client was innocent. They didn't like him because of, his political demographics. And, and so I got into a big disagreement and ended up, leaving the program, leaving that particular part of the program. Because they couldn't handle disagreement. It was one of these, all they would ask you is, well, how does that make you feel? How does that make you feel? I was like, you guys being idiots and letting an innocent person fry? How do you think it makes me feel? So I'll never forget this. One guy looked at me and goes, oh my God, you have no respect for authority. And I was like, yeah, so, but I mean, that's what these people are accustomed to. They're just deference to whatever their moral virtue signaling is. I've been following some of the University of Virginia law's comments on the Chauvin case, and you can see they're just walking on eggshells. All these law professors want to make sure they don't offend or upset anybody and say exactly the right thing. And it's just pitiful and sad how bad our academy has become. The Enlightenment principles have been lost, and we're training idiots and developing idiots.
I'm gonna and shout out to Gad Sad and Dave Rubin in their books. Don't burn this book. Dave Rubin and Gad Sad, Parasitic Mind. It actually, it didn't inspire me. It did make me a little more courageous to stop pussyfooting around, saying things the way they need to be said directly. Let's see here. We got Cleopatra says, I may have been out with Winston when you discussed this. What do you think of the Navy admitting to seeing pyramid-shaped UFOs? Cleopatra, that will be on an off-platform discussion, maybe on locals. One thing actually, so Bhattacharya, it's going to proceed to discovery. It's going to proceed, and I'm going to be following it because that one irritates me personally.
If they're smart, they'll settle it before the discovery gets developed.
And that what and there and it would be a public apology and a written apology and some monetary compensation. Other question, actually, someone had asked this before. The Washington settlement for the two kids, and I am calling them kids, involved in the Uber carjacking that led to the
plea deal. Yeah, if you whack people for the right reasons, it's okay. You'll get to take a walk.
The only thing that people again people are going to say sympathetic Canadian. The kids are 13 and 15 years old, and I didn't when I realized that they were that young. It makes everything more tragic and more disgusting and more unpalatable. The only question is there can be no justice in this ever. The only question is going to be what is the punishment for this? Now their plea deal is they're not going to go to jail. I mean, what do they do? Counseling? I mean, I don't actually know what the plea deal involved, other than them not being punished in any meaningful way.
To my knowledge, no jail time at all, which sends the wrong signal for sure from a deterrence perspective. Though I have problems with our criminal justice system. I think it's partially insane. We develop people to become part of the permanent criminal class. But there should have been something to remove these individuals as threats from society from the near short term, and some degree of deterrent message sent, whatever that message was. That is the failure to have. But again, it's just the hypocrisy and inconsistency. So it's that, if you're on the right political side, you get treated. We have a two-tiered system of justice that's getting worse and worse, where it's not just the powerful and the protected are the powerful and the privileged are now protected. It's also the politically just being on the right side makes you protected now, and that's a problem.
Well, and this is another thing. So civil liability, the guardians of minors who cause damage can be held liable, but criminal liability, Robert, I mean, I have to stretch my criminal recollection, but to hold the parents criminally liable for the negligence of their minor children, can that be done in the States?
Yes. And there's you have a lot of authority in the juvenile context. Maybe, in my view, too much authority the state has, but there isn't a lack of authority. That's for sure.
Okay. All right. And then again, do the class. It didn't seem people were interested in the Google class action lawsuit based on just the interest in the video. In a nutshell, class action lawsuit against Google in Massachusetts on the exact same basis of the FTC complaint that Google was gathering data on minors without the express consent of their parents. The allegations are cut and paste effectively from the FTC complaint. And there's a class action lawsuit for damages. The damages being the profits that Google made off of this illegal data collection, which violated a Massachusetts state law, which, according to the Massachusetts state law, is intended or supposed to get the same interpretation as the Federal Trade Commission Act law itself. So basically, it is the federal law at the state level. I mean, it's a no-brainer of a case, or is there any defense that?
It's what it's showing is that a bunch of plaintiffs' lawyers are sharks in the water circling big tech, and they're looking for every place to sue big tech because they realize how politically hated big tech is, and you're going to see more and more and more and more of it. And I don't think big tech has yet come to terms with it. And so here, it's something a lot of jurors are not going to be. Hold on a second. You targeted my 6-year-old kid for commodification and of their information without my consent, when that could have been, a 2-second process, and you did it en masse, and you knew you were doing it, and you're even manipulating my kid. That's the kind of information that the jurors are not going to sit well with. So all of big tech is facing major legal blowback, and they underestimate what's happening to them politically is going to make those jury pools ready to do serious damage to them. Put it this way, plaintiffs' lawyers right now see big tech like they once saw big tobacco. And we all know how that turned out.
Amazing, actually. And if anybody doesn't know, bottom line, Google collects data even when you're not logged into your account for targeted ads, which they sell at a premium, as opposed to generalized ads, which you see on TV. So that's the basis. That was the basis of the FTC complaint. YouTube paid $170 million settlement for that complaint. And I suspect that's going to be one darn good indication of culpability in the class action sense. So, I mean, I think it's a no-brainer. It's just a question of how much and how many other states have laws that are going to be similar that are going to allow this type of lawsuit.
They almost all have that exact same statute. It's basically a consumer trade unjust enrichment statute.
What can Google do actually just to avoid class action lawsuits in every state? To say, look, we want to settle all of them.
At least in kids' case, do what they said they were doing, which is get consent and full public information.
No, but I mean, what can they do to avoid civil lawsuits for past conduct? I mean, can they ask for some class action global settlement of all cases across the states?
But then they would have to get the way these lawyers. There's a reason why these lawyers are bringing it by state. They're precluding that possibility. So so they can try to consolidate if there's multiple claims in multiple states. But my guess is they're just going to pick them off one state to the next, to the next, to the next.
Okay.
Because I work with these guys. John Grisham's book, King of Torts, is a good book to show you the good and ugly of that side of practice.
All right, now I say, Chairman of the Board says, please read, you, Barnes, Gruler, and Nate, or as I call you, the Mount Rushmore of YouTube lawyers, give hope for future thoughtful conversation online. Love the support you show each other. Inspiring. Thank you very much, Chairman of the Board with an ED. Now, I hear noise coming downstairs sooner than later, and oddly enough, it's going to be kids. Robert, do we have any questions? Do we have questions from locals?
We answered almost all of them. There was also one from Antoinette about can Eric Nelson take protective steps to deal with his security and safety if there are acquittals? I assume he has. Some defense lawyers don't take that seriously enough. You can look at what happened to the Israeli lawyer who defended the man falsely being accused of Ivan the Terrible. A great documentary on that subject that I did a famous cases episode on at vivabarneslaw.locals.com, where I will be after the show with a live chat for folks that want to tune in. But so I assume he has, but sometimes they don't take that seriously enough. I think he should. I have protective security people, but I'm able to get in and out of situations pretty comfortably, but don't publicly disclose what those are.
And Robert, I just pulled up Cleopatra's comment because it's so true. The ads are always targeted. I did the research for the Barstool lawsuit. I immediately started getting Michael Rappaport, type medicine. The kids have distracted me. I immediately started getting Herpecil ads in my spam account on my david@vivafry.com. It's crazy. It's everywhere. Children, would you like to say, do not touch the thermostat. It's summer. Okay. Brendan, you can bring the dog. Okay. This might be the time to end the stream, everyone. Robert, give us something to look forward to for the week in terms of inspiration.
Well, two things. One, we're seeing people fight back against big tech that might expose them in a meaningful way, of which both the Google suit and the Project Veritas suit are of a piece. And the fact that somebody like Ford could fold as fast as he did in Ontario to his lunatic lockdown rules is a great indicator of how the court of public opinion can reshape the direction of society. So that's why everything ordinary people do out there on a day-to-day basis does make a difference. The greatest trick the devil ever pulled was convincing people he did not exist. The greatest trick the system ever pulled was convincing you there was no chance for you to resist. Today and this week, we learned otherwise. So continue and march on.
Amazing. Everyone, enjoy what's left of the weekend. Robert, we're going to see what we can do for the stream tomorrow. But everyone, thank you very much for tuning in. Thank you for the support. Robert, stick around. We'll say our proper goodbyes. Enjoy the rest of the weekend, people.